A very good evening to all of you, and you're joining in with the law and order discussion today. And today we are going to discuss about the fundamental rights chapter of the Constitution of Sri Lanka and how a citizen can enforce his fundamental rights. And we are happy to welcome Mr. Shantha Jayawardena, attorney at law.
Thank you very much, sir. Thank you very much for the invitation.
And it's a pleasure to have you at Sri Lanka Rupavahini channel.
Thank you very much. It's a privilege to be here. So.
And my first question when it deals with fundamental rights, now the United Nations celebrated the 70th anniversary of the Universal Declaration of Human Rights in 2018. What exactly are fundamental rights and how exactly is it important for citizens?
Yeah, to put it simply, Shahara, fundamental rights are those basic rights of individuals which are necessary for kind of in a democratic life, which are recognized in the Constitution. So, when you talk of human rights cover a wider spectrum of rights, but when you talk of fundamental rights, you talk of the rights which are recognized in the Constitution and constitutionally protected. So, human rights is a wider concept, fundamental rights is a narrower concept. So, human rights is a more international law concept, which is now often used and resorted to, but fundamental rights is more a constitutional law concept. So, when you say fundamental rights, there are several rights recognized in the Constitution. In our case, in our Constitution of 1978, Chapter 3 recognizes certain rights. So, those rights we call them fundamental rights. So, which are basic to human existence and a democratic life. So, those are fundamental rights.
So, the fundamental rights chapter of the Constitution has recognized certain rights or liberties which every Sri Lankan citizen, or is it expanding beyond a citizen?
Sure, certain rights are for citizens. Then certain rights any individual, even a foreigner living in Sri Lanka, is entitled to. For instance, if I briefly refer to the rights recognized in the Constitution, Article 10 recognizes the freedom of thought and religion, then Article 11 freedom from torture. So, those two rights are guaranteed to any person. But of course, when you go down, the other rights, political rights like freedom of expression, freedom of joining a trade union, peaceful assembly, those rights are guaranteed to citizens. So, there is a slight difference here. Those rights under Article 10 and Article 11 are guaranteed to any person living in Sri Lanka. So, that's a wider category, guaranteed to a wider category, whereas the other political rights are guaranteed to citizens.
And also, when we talk about fundamental rights, there is a criticism that people do not enforce their rights. People whose rights are violated often choose not to enforce it, or they do not know how to enforce it.
Yeah, perhaps due to ignorance, lack of knowledge, perhaps for financial reasons, people may not be aware of their rights. So, in certain cases, sometimes we can see gross violation of fundamental rights, but people don't come forward. So, that happens, but then it is the responsibility of the government, all three organs of the government, as Article 3 of the Constitution 3 and 4 says, to promote and advance fundamental rights. So, the government through various institutions, in particular the Human Rights Commission, I believe the government through the Human Rights Commission has to promote and make the people aware of their rights. So, as far as the court is concerned, the court of law cannot go to people and ask them to file cases, but of course, we know in certain circumstances even the Supreme Court goes to the extent of entertaining direct communications to the Chief Justice or to the Supreme Court complaining of fundamental rights. So, there are a lot of reasons why people do not come to court, but at the same time, then on the other hand, it is a responsibility of the government, in particular the Human Rights Commission, through which the government kind of secures human rights, promotes human rights, that has to work towards educating and making people more aware of their rights.
So, raising awareness is important. So, in the same line, may I ask you, if a particular person's right is violated, for instance, let's say my right is violated, what remedy or what should I do next? What remedies do I have?
Yeah. The most effective remedy is to go to the Supreme Court and challenging the violation of fundamental rights. So that is the sole and exclusive jurisdiction to hear and decide fundamental rights cases is conferred on the Supreme Court. So that's the most effective remedy. Then of course then there are then there are few other institutions you can resort to. One is the Human Rights Commission. Then also the Constitution provides that you can complain to the Ombudsman, that is the Parliamentary Commissioner for Administration for fundamental rights violation. But the most effective remedy is if the Supreme Court is going before the Supreme Court by way of a petition addressed to the Supreme Court and then seeking relief. That's the most effective remedy, and that has to be the number one remedy that the people should resort to.
And also going to courts would be one alternative, as you suggested. You also spoke about the Human Rights Commission.
Yes.
Now, the Human Rights Commission was established in 1996 and it works on a wide number of areas. What exactly is the role of the Human Rights Commission? Is it only to give remedies for human rights violations, or does it play another role as well? And also, what type of remedies can the Human Rights Commission give?
Yes, the remedy as far as individual complaints are concerned is all they can do is to first try to settle, resolve the issue. If not, then proceed to an inquiry and make a recommendation. The issue, the most which is kind of now known and discussed, the issue with regard to the recommendation of the Human Rights Commission is that they are not enforceable through a court. So it's not binding on the parties. So even if a citizen complains and gets a recommendation in his or her favor, the perpetrators or the authorities or the respondents have violated the fundamental rights are not bound to carry out the recommendation of the. Of course, there is a different procedure of placing the report before the Parliament, but that's beyond the control of the complainant. So that's where it lacks the capacity to enforce. That's where the difficulty with the Human Rights Commission is. But of course, I must also say, share when you say go before the Supreme Court as the most effective remedy, you have to go within a period of 1 month, the Supreme Court, and so perhaps people living in faraway places may be finding it difficult. Perhaps they are unaware of the fact that they have to come within 1 month. But you see, the urban people who are educated people, they know that when there is a violation of fundamental rights, they have to go to the Supreme Court within 1 month. But the more the people who are living in remote areas, the more vulnerable groups, they are sometimes unaware of the fact that they have to go to court within 1 month. Of course, as far as the Human Rights Commission is concerned, there is no time bar. So can come even later than 1 month, maybe 3 months, 4 months. I am not quite sure whether they have any administrative timeline drawn, but the law, the Human Rights Commission Act doesn't speak of a timeline. So those two remedies are available. The most effective remedy is
going to
undoubtedly the Supreme Court.
And you also spoke about the Ombudsman. I don't think this is well spoken of among the legal fraternity as well as the common citizen, because the first two options is obviously to go to the Supreme Court, and secondly to go to the Human Rights Commission, and thirdly no one speaks about going to the Ombudsman. Is it because it's ineffective, or is it?
It's again the same problem that we can see in the Human Rights Commission, because the orders are not binding. So sometimes you fall into more trouble by by complaining with these authorities about individual complaints, because perhaps they take 1 or 2 years to make a recommendation, and then after 2 years you have a non-binding recommendation. So this is one of the reasons why people don't resort to the Human Rights Commission or the Ombudsman. But in a way, in certain instances they have been effective. Those institutions have been effective, but as not as effective as a court of law.
And also, when we talk about fundamental rights, can we elaborate on what are the rights protected under the Constitution?
Yes. And firstly, the Chapter 3 of the Constitution recognizes our fundamental rights. The first under Article 10, Chapter 3 starts from Article 10. Article 10 guarantees the freedom of thought, conscience and religion, which allows you to have your own religious belief or not to have a religious belief. So that's under Article 10. Then Article 11 guarantees the freedom from torture, for instance, which is one of the most common violations maybe 10 years back, 15 years back. For instance, if a person is taken into police custody and you are subjected to torture at the police station, then your rights are violated. Your rights under Article 11 are violated. So that is what is meant by saying freedom from torture. So torture also can have different forms. It can be mental, can be physical. So mental torture is also has now been recognized by our Supreme Court as well as a form of torture. Then under Article 13 is where you are guaranteed the freedom from illegal arrest. If a person is to be arrested according to the procedure laid down in the law, and in the same way Article 13(2), the sub-article says guarantees the freedom from illegal detention. So that is not that you can't be arrested, but has to be, if you are to be arrested or detained, that has to be done in accordance with the law. So principle is the Criminal Procedure Code, which lays down the procedure for arrest and detention. Then of course, for instance, if there is an emergency, then the emergency regulations will come in. Then under Article 14 there are several political rights: freedom of expression, then the right to join a trade union, form a trade union, to peaceful assembly, then to manifest your religion, then freedom for himself or in association with others to enjoy and promote his own culture and to use his own language, the freedom to engage by himself or in association with others in any lawful occupation, then freedom of movement and of choosing his residence within Sri Lanka, then the freedom to return to Sri Lanka. So those are political rights under Article 14. Then of course under the 19th Amendment, the right to information was recognized under Article 14A, which was introduced in 2015 under the 19th Amendment of the Constitution. So those are the rights, briefly, but there are a lot of judgments interpreting what is meant by freedom of expression, what is meant by joining a trade union, what is meant by freedom of movement. So those rights are defined by the Supreme Court in several judgments and interpreted. So this chapter, the fundamental rights chapter, has been in force for 4 decades now. So there are a lot of judgments. So those are the rights recognized. So for instance, if I may give an example of freedom of expression, if say for instance a certain film is banned or not allowed by the Public Performance Board or by a minister or any other authority, public authority, then that infringes your, can say that it infringes your freedom of expression. So and also we must also note that there is no right to strike recognized as a fundamental right. It is the freedom to join a trade union. So those are some of the basic details of the rights recognized in the Constitution.
And when talking about freedom of expression, a common question I think a lot of citizens might have is, do you actually have a right to protest? Now, there are a lot of protests which go on in Colombo. Sometimes they do also hinder the day-to-day activities of citizens. Now, at that point, certain people argue that protests should not be carried out. And also people who protest argue that it's their right to maybe block the road and engage in certain protests. How does the fundamental rights law deal with these situations?
Of course, interesting issue, Shah. I've seen on social media people talking against protests, but again, if you come back to the fundamental rights as well, for instance, most of these protests I've noticed are protests by public servants relating to their salary anomalies. They are asking for salary increases, salary allowances, those kind of issues. But if you really look at the issues, there is no institution to look into those grievances in Sri Lanka. For instance, there is the Administrative Appeals Tribunal which has certain powers to relating to public officers, but they don't have the power to go into salary issues. Then also even the Supreme Court is very rarely intervenes into a salary issue, because that is more a policy issue. So then so those kind of issues we have to also remember when you talk of protests, that people sometimes have no forum to go, in particular the public servants. Then of course the other category of protesters are mainly the universities, young activities, but of course then freedom of expression certainly covers the right to do a protest, but then there are other penal laws. You can't obstruct the public, you can't obstruct vehicles, those restrictions are there. And also rights under Article 14 can be restricted by law. So there are restrictions. For instance,
on what grounds can you restrict the freedom of expression?
Freedom of expression on that is under Article 15 shall be subject to as prescribed law in the interest of racial and religious harmony, or in relation to parliamentary privileges, contempt of court, defamation, incitement to an offence. So those rights can be restricted. So certainly there are judicial pronouncements saying that if you can remember Janagosha case, where a person took a drum and was beating the drum in public, and the police split his drum. He complained to the Supreme Court, and the Supreme Court said he has the right to protest. This is commonly referred to as the Janagosha case. It was some in 1993 the incident happened. So certainly it covers to a certain extent, but certainly you can't go beyond the restrictions imposed by law.
And also when it comes to restrictions, also the other fundamental rights also have restrictions, I believe.
Yes, except two, the freedom of thought and religion that can't be restricted, and also freedom from torture. Those two rights cannot be restricted by any means. Those are called entrenched fundamental rights. But the other rights on morality, national interest, national economy, national security, on those grounds, the other rights, in particular the political rights, and for instance, joining trade union may be restricted for expression. Those rights can be restricted.
So a person's right to religion cannot be infringed on any circumstance.
Cannot be restricted on any by at any cost. That can't be restricted. Your freedom of thought and to believe a particular religion, or not to believe a religion, not to have a religious belief, cannot be taken away. The government cannot take it away. And similarly, freedom from torture. Even a hardcore criminal has that right. Even if you are a criminal and taken to the police station, you can't be tortured at the police station. So that is not a right that can be taken away. So those are goes to the core of human existence. So you can't. Those are entrenched by the Constitution itself.
And also, when we talk about freedom from torture, that's a very controversial area when it comes to Sri Lankan administration. We have so many cases where the police as well as government officials are accused of torturing suspects, torturing criminals, torturing prisoners. So how does the law relating to this practically take place? Because we also see a very interesting case of Sriani versus Siddamalgoda.
Yes, of course. Now the situation is not as bad as it was in the 90s, Shar. Because if you look at the reported cases in 90s, in 80s and 90s, there have been a lot of torture cases. But now the police officers and the other officers involved in arrest or detention, they are aware of the consequences. They know that there is this right recognized in the Constitution, and they have to face the consequences of a court order. And then also now we often see the Supreme Court itself, when finding rights under Article 11 is violated, they direct the Inspector General of Police, or where the prison officers are involved, directing the Commissioner General of Prisons to take disciplinary action, and also that results in the officers losing their career prospects, promotions. So now there is a reduction of cases, but basically how it happens is you have to when you are tortured at a police station or at the prison or anywhere after you have been arrested by a public official or public authority, then of course you have to complain to the Supreme Court within 1 month. But if you have been incarcerated, you are excused for that period. So then a torture case mainly depends on the medical evidence, medical report. So but if somebody is tortured at a police station, then the first thing they must do is to produce themselves. The police does not produce them when they are informed the magistrate, when they are produced before the magistrate, then of course then through their lawyers will have to make representations to be produced before a judicial medical officer for a medical examination, judicial medical examination, which is very crucial. So in a torture case, yes, medical evidence is the crucial factor. Of course there is a criminal offence as well. Torture is a criminal offence as well now, so a separate criminal offence. So then the officers or the responsible public officers will be dealt with under the criminal law as well.
And I would like to post a question to you, not as a lawyer, but as a citizen and a human rights activist. Should the current law on fundamental rights change? Should it be more closer to the people? And what are the new rights which the government should recognize? And also, I would like to add a second part to the question. Now, there is allegation that human rights cases or fundamental rights cases in the Supreme Court take a very long time for the judgment to be delivered. So, yes. Do you propose any changes or law reform?
Yes, if I may answer the second question first, Shara. Yes, it takes a long time, but the issue for the Supreme Court is having is that the Supreme Court has only 11 judges, including the Chief Justice. That was the number of 11 was fixed in 1978 when the Constitution was introduced. So that was 40 years back. Perhaps now the population is doubled, and the number of cases listed before the Supreme Court for a day is sometimes even 30, 40. You get 3 or 4, 5 fundamental cases. Then for leave to proceed, then there are about 10, 15 civil matters for support. Then there are 6, 7 argument cases. So it's simply beyond the practicality. So 11 judges can't cope with that. So I believe the immediate, if the fundamentals are to be not only fundamentals, even to make the other legal remedies more effective, I think the legislature will have to amend the Constitution. We have been waiting for a new Constitution for a long time, but we can't postpone it until then. We'll have to increase the number of judges in the Supreme Court. I believe that is a must. Then that is the cause for the delay. If there are 25 cases, that is humanly impossible. Maximum the court can hear maybe 5, 6 matters a day. More than that is impossible. So the Constitution says that the fundamental rights case has to be heard and concluded within 2 months. But in practicality now, it takes in most of the cases takes more than 2 months to support the case for leave to proceed as well. That is to get through the first step. So that is mainly because the lack of inadequacy of judges, number of judges. So we need to amend the Constitution and increase the judges. The first thing to expedite the hearing of fundamental rights cases as well as any other case. So that is my response to the second question.
Part.
What was the first question? I'm sorry, Sharif.
The first part, my question was, now as an activist, do you think Sri Lanka should recognize more fundamental rights or to expand protection of fundamental rights?
Yes, what we now have in the Constitution are the basic liberty rights and then fundamental rights. What we don't have in the Constitution are the socio-economic rights, like right to housing, right to adequate health care, right to education, which fall within the category of socio-economic rights. But conceptually, if you look at it, it's better if you can have them. But if you conceptually, if you look at it, and even practically, to guarantee those rights to all citizens, then you need a lot of resources. So if the government is to guarantee those rights, government needs a lot of finances now. We being a third world country for now 70 years at least. So, we perhaps we will be in a difficulty to enforce those rights, but at the same time we must appreciate that the Supreme Court in several instances has interpreted Article 12 of the Constitution to include several other rights. For instance, all the school admission cases, for instance, if somebody's application to admission to a government school is refused arbitrarily, then that is those applications cases are entertained under Article 12. So, to a certain extent education rights are by judicial interpretation are now covered under Article 12. Even university, there are a lot of there were university admission cases sometime back. There were a lot of cases, and every year the Supreme Court, I believe, gets at least about maybe 50 to 75 school admission cases. So, but what is outstanding is in particular the health and housing. If you look at the socio-economic category of socio-economic rights, but the difficulty then again is to how to enforce them. How can the government itself be bound by those rights when they don't have resources? But of course, then there is a lot of criticism as to how the resources are allocated and used.
Okay, so there is of course room for law reform, recognizing more fundamental rights, and also the basic aspect which needs to be emphasized is that fundamental rights law should be made more aware to the people, and especially students should know about fundamental rights in Sri Lanka. So with that, we would like to wind up today's Law and Order program, and we would like to thank Mr. Shantha Jayawardena, attorney at law, for participating in today's Law and Order program on behalf of Channel I, and we would like to wish all our viewers a pleasant night.
Thank you very much, Shara, for the invitation.